The University of Medicine and Dentistry of New Jersey Office of Ethics, Compliance, and Corporate Integrity presents the Sunshine Act. The Centers for Medicare and Medicaid Services, to be referred to as CMS for the remainder of this presentation, issued a Notice of Proposed Rulemaking, announcing the publication of draft rules to implement Section 6002 of the Patient Protection and Affordable Care Act, commonly known as the Sunshine Act. The much-anticipated regulations were published in the Federal Register on December 19, 2011. CMS's proposed rule confirms that nationwide, disclosure requirements are here to stay. Now is the time to prepare, both from a systems and processes perspective. The purpose of the act, set forth by Senators Chuck Grassley of Iowa and Herb Kohl of Wisconsin, is to achieve public disclosure of financial relationships between physicians and the pharmaceutical, medical device, and biologic industries. To summarize the act, it requires pharmaceutical, medical device manufacturers, and biologics companies to report payments made to covered recipients. It requires companies to report physician ownership interests in their companies outside of publicly traded securities. It preempts existing state laws with the same information requirements, outlines penalties for non-compliance, and requires information to be posted on a public website. Who's covered by the Act? Any applicable manufacturer of a covered product that provides payment or other transfer value to a covered recipient. A covered product is when a payment is available for the product under Medicare, Medicaid, or CHIP. An applicable manufacturer is a manufacturer of a covered product, which can be a drug, device, biological, or medical supply, and holds FDA approval, licensure, or clearance for the product. And a covered recipient is a physician, physician medical practice, physician group practice, or teaching hospital. What's reported? The name of the recipient, the business address of the recipient and Medicare billing number, the value of the payment or other transfer value, the dates on which the payment or other transfer value was provided, a description of the form of the payment or other transfer value. Also, consulting fees, compensation for services other than consulting, honoraria, gifts, entertainment, food, travel, education, research, charitable contributions, royalty or license, current or prospective ownership or investment interest, compensation for serving as faculty or as a speaker for a continuing medical education program, grants, or any other nature of payment or other transfer of value. Aggregate reporting. Information submitted shall include the aggregate amount of all payments or other transfers of value provided by the applicable manufacturer to covered recipients during the preceding year. This includes entities and or individuals designated by or on behalf of the recipient. The Sunshine Act requires that CMS delay the publication of research payments until after the earlier of FDA approval, licensure, or clearance of the underlying product, or 4 years after the payment date. For payments occurring more than 4 years ago, CMS would automatically publish the payments regardless of whether a delay is indicated on the filing. What's excluded? Payments under $10 if the aggregate amount for the recipient is under $100, product samples, educational materials that directly benefit patients, in-kind items for the provision of charity care, payments through a third party when the recipient's identity is unknown to the manufacturer. There are two classes of penalties. The first is failure to report, carrying a $1,000 to $10,000 penalty for each payment or ownership interest that goes unreported, carrying a $150,000 annual maximum penalty. The second is knowing failure to report, carrying a $10,000 to $100,000 penalty per violation, with an annual maximum of $1 million. When will this happen? Reporting begins January 1st, 2013. For updates and more information, please visit us online at ethics.umdnj.edu. Thank you.